Okay, hi everyone. I'm Tom Hooper from Bird and Bird. I'm a trademark attorney that's been working in trademarks for around 15 years. I do a wide range of contentious and non-contentious work. That includes filing around 30 company name tribunal actions a year for various different clients. And today we're here to talk about protecting your clients' brands with a focus on company names tribunal. So what are we talking about? Just to start, to give you some background, prior to the 1st of October 2008, an individual or company wanting to challenge a company name registration in the UK had limited options. If the objection was that a newly registered company was the same as or too like an existing company, it was possible to request the company's registrar to take action. However, the registrar was not able to entertain complaints arising from a conflict between an earlier rights holder. So the primary action was available only in the circumstances to go to court when passing off a trademark infringement. In light of the increasing concerns that brand and trademarks were vulnerable to being hijacked through opportunistic trademark registrations in the same way that cyber squatting became a significant issue in the 1990s, and in recognition that in pursuing action before the courts to resolve such matters would be both very time-consuming and very costly. A new mechanism was therefore introduced in the Company Names Act, the Companies Act 2006, specifically at Section 69. So for the first time, Section 69 introduced specific grounds to object to a registration if the company name was either the same as a name associated with the goodwill of the applicant, or sufficiently similar that such use of the name in the UK would be likely to mislead by suggesting a connection between the company and the applicant. The UK Companies Tribunal was established. This is also known as the CNT or the Tribunal, depending on who you talk to. This was established to deal with complaints under the specific Section 69 regime. Since then, some of the defences have been amended. Actually, last year they were amended, and so the Act is slightly different to when it was initially enforced. We will come to the current reading of the Act later. Those changes are essentially to make it harder for opportunistics to encroach on your client's brand identity. We're going to look at the CNT in detail today, but to start with, it's worth keeping in mind that this is a UK Intellectual Property Office-based action. It's not a court action, and this means the majority of the action takes place in Newport in Wales. And for any of you that handle trademark oppositions already or related proceedings before the UK IPO, the procedure in itself and the powers of the CNT or the tribunal are quite similar. Though I must stress that there's less adjudicators that work on the CNT proceedings, and so they're less available to support than they are with, for example, trademark oppositions. And we'll come to roughly the numbers of those adjudicators later. Today we'll give you information available to consider when and when to not choose the CNT proceedings over traditional court proceedings for infringement. Importantly, we will also look at the legislation, and then we'll come to some practical and strategic considerations, as well as some of the most important cases to consider and keep in mind, and also some of the most recent cases of the CNT Tribunal and the High Court.